Welcome into another edition of Legal Access. We get together every Thursday at this time to give you access to different aspects of the law. Today we're going to be talking about family law. That's essentially divorce, custody, separations, and adoptions. And here on the panel to talk about that and answer your questions, to my left, first of all, we've got Stephanie Vaught-Little. Welcome back, Stephanie.
Thank you.
To your left, from the McGuire Law Firm, Ian McGuire.
See you, Dave.
And at the end of the table, for no specific reason, Randy Mullins.
Always a pleasure, Dave.
Two great guests, Dave, and it's always a popular topic, family court. Stephanie's office is on Main Street in North Myrtle Beach. Actually, we all worked in there for Mr. John Clark years and years ago. And Stephanie's practice is you do family court, of course, which is what we're doing today, and personal injury and criminal and anything else. That you
I do wills and estates.
Wills and estates. So, and Randy, it's great to have you back. Randy's also, you know, there's not many lawyers that can handle different areas of law the way things have. It's, in the old days, that's sort of the way it was. You had the general practice. And frankly, it's scary for a lot of us to do more than one thing. But Randy does, and does everything really well. So he's one of the few who left. And I think, Stephanie, it sounds like you are as well doing that. But always great to have Randy on the show. He does a fantastic job, and he's a great lawyer. And you're a mediator as well, which is an area we always talk about being so important to really the practice of law now, where years ago we're like, why didn't anybody think of that a long time ago? Because it resolves so many cases. So anyway, topic today, Dave, is family law, but as you've heard, you know, our two esteemed guests can handle a lot of different topics. So if you have a question outside family law, don't be scared to give us a call at 843-848-8080. That's 843-848-8080.
Well, as Ian said, it's a very popular topic, so don't wait to the very end of the show to try to get your call in, because we might not be able to fit you in. So call right now. Again, the phone number is on your screen, so give us a buzz. Stephanie and Randy, I know that you obviously have law degrees, but when you're in the middle of your practice, does it feel like you need a psychology degree when you're talking to some of these people in the midst of a divorce or a trial separation?
Absolutely. But we've got a lot of good professionals here locally, and I rely on some of them, you know, when I have a bad problem that I need to get solved. You know, we've got a lot of talented people here locally that help us out in family court.
Exactly. I didn't realize how much a counselor at law was actually a counselor as well too. But I'm with Randy. We have a lot of good professionals, and you know, the ones that need to have to go to see those, whether it's for the client or for their children or whatever, there's a lot of good professionals in the area.
I know it might be counterintuitive, but do you ever find yourself when you're talking to a couple or to an individual to say, hey, you know, I think you might be able to work this out. Why don't you get back? It doesn't sound like it's as bad as you think it is.
Well, you know, domestic law is expensive. Neither Stephanie and I are cheap dates. And we're both full up most of the time. You know, I tell people up front, are you sure this is what you want to do? Because I'm a pretty good lawyer, but I suck as a marriage counselor.
Right, and the family court does, I mean, they are for reconciliation of marriages. Really, they don't want people to get divorces. In fact, when you go for a divorce, the judge has to ask, is there anything I can do to reconcile your marriage? So I'll ask them, have you tried marriage counseling and things like that? Yes.
Well, I know the rules in South Carolina are geared towards trying to keep couples together. That's why I have a 1-year limit on separation. They want to force you to be separated for an entire year before you go forward with the divorce.
Exactly.
You know, that's why there's even a cooling off period with fault-based grounds. Statute says that we can't, that's statute or law, not things in the park the pigeons poop on. But the statute says there has to be 90 days from the date of filing to you hold a hearing on a fault-based ground.
And when you're talking about fault-based abuse, assault, drugs and drinking, is that what
that's basically it. You know, we're talking adultery, physical cruelty, and habitual addiction to drugs and alcohol. But still, there's that 90-day cooling off period because people are human and they make mistakes, and the court wants you to stop and think about it.
Some of the other separation rules that are out there, somebody might say, okay, I don't have enough money to go out and get my own place to separate. I'm just going to live upstairs and my wife's going to be downstairs. That doesn't count, does it?
No, no, it does not count. Our courts have said that you have to be in separate residences. You don't actually have to change your driver's license or things like that, but you have to live in separate residences so that the community knows that you're living separate and apart. No one knows what you're doing behind closed doors, even if you have a padlock on, your door. You're still going to have to live separately.
I remember with COVID, that was a big problem, right? People couldn't
Yes.
go anywhere and they were sort of stuck.
Oh yeah, that was a lot of divorces from COVID.
Too much time together.
Yeah, too much time together, and then too much. I mean, people just felt differently. Somebody wanted the vaccination, the other one didn't. I mean, just new things to argue about.
Yeah, yeah.
Phone numbers on your screen if you'd like to give us a call. Family law is our topic here today on Legal Access. Let's go to Conway first off. Rosemary's on the line with us. Hi, Rosemary. Thanks for calling in today. What's your question for the panel?
Yes, I just had a quick question, which was that I have to get my will written up, and I promised my daughter that I would do everything before the end of the year, and we're really getting close there. So I'm wondering whether or not your firm handles wills.
Both of our firms handle wills, unless it's
Both of these. So not McGuire Law Firm, but both.
That's, me and Ms. Vaught-Little both
Yeah.
handle wills, and certainly you need to plan. We call it end of life package.
Yeah.
And it's good to do that, but you don't have to drive and see us in North Myrtle. We want you to and eat at our restaurants, but lots of talented lawyers in Conway can write you a will too.
Okay. Well, what would I look at under in the to Google it or whatever, please?
Just Google. Well, there's several good sites. Justitia, Facebook even has
Wills and
recommendations. Yes.
Yeah, wills, trusts, and estates, and that,
Yeah.
and
Okay.
that'll pop up some good lawyers in the area that do that. Yep.
All right.
All right, Rosemary,
be
thanks
great.
for calling
Thanks
in.
for your
Hopefully
time
that
and
helps
having
out.
Thanks for the call.
You have a
Good
great
luck.
day.
Good luck.
And as far as wills are concerned, since both of you guys do wills, if you're in the middle of, since we're doing family law here today, if you're in the middle of a divorce and something, God forbid, happens to you before you get a chance to change your will after you've gotten divorced, so what does the law say about, what happens to your property?
After your divorce?
Yes.
And you forget to change your will?
Yeah.
The law says that if you have left something to your spouse in your will, that it severs by law. They can't inherit if they did not change. If you do not change your will after your divorce. Okay. Also, with insurance policies, if you've named your spouse as beneficiary, the law severs that relationship as well.
All right, before we go to break, let's go to the town that's going to be hosting the big race this weekend. Darlington. Joseph is on with us. Hi, Joseph. Thanks for calling in. What's your question today?
Well, my question is, I have a daughter from a previous relationship, and I just want to know, how would I write that up if I wanted to leave her something or nothing? How would I write that will up?
You want to take this one?
Sure, you guys do wills. So.
Well, Joseph, what you need to do is make sure you have a written will properly executed. You can do that at most firms. You're in Darlington. There's lots of good firms in Darlington that can do that for you. It's hard to disinherit a spouse. A spouse can elect against the estate. It's easy to disinherit a child. And if you want the child to specifically have something that's been in the family for a long time, put it in the will and be specific about what you want. But you can leave a child $1. You have to acknowledge you have the child. Otherwise, they say, well, Dad forgot about me, and if he remembered, I'd be in the will. Well, make sure you leave them something, even if it's $1. A lot of lawyers put a no contest clause in there too, so that if the person contests the will, they forfeit any right.
Joseph, thanks for calling in today. We appreciate that. Hopefully that helps you out. And remember, we are talking about family law here today, so divorce, custody, separation, adoption, even though both Stephanie and Randy can handle questions about wills as well. So any questions you have, please make sure and get them in. Still got about 20 minutes left on the show, plenty of time to get you in. Give us a call here today, 848-8080. It's Legal Access, brought to you by the McGuire Law Firm. Welcome back. It's Legal Access brought to you by the McGuire Law Firm. We're talking about family law here today. Divorce, custody, separation, adoption. If you have any kind of questions, we've got plenty of time to get you on, but don't wait to the very end of the show. Phone number is on your screen, 843-848-8080. I know one of the calls we get on a regular basis about family law is about grandparents' rights. Now, if there's a divorce that's happened, the grandparents are like, well, I still want to be able to see my grandkids. Do they have any rights to be able to do so?
Well, that's been a hotly litigated thing over the years, David. One of the things that has to happen here is that the parent has to be denied access, or the grandparents have to say that both parents are unfit. Unfit's a high burden of proof. Courts want to foster those long-term relationships, but you have to go into those cases very carefully, and they're very expensive. Steph, what do you think?
Oh, I agree. And just for, there is fairly newer case law that allows grandparents to have visitation.
Right.
But it's always in a situation where either the parent who is the child of the grandparents who want visitation has
Right.
either become deceased or just out of the picture altogether. Yeah.
A lot of times the way our society is right now, there are grandparents that are raising their grandkids, and then the parents want to come back into the picture and get the kids back, which legally and biologically they can do that as long as they meet the standards that you were talking about, Randy. But at that point, the grandparents are like, "Oh, hey, I've been raising this kid for the last 8 years. I want to be able to hold on to him," or whatever.
Yeah, and there are ways to do that. It's very specific, case specific, and like Randy said, it's very expensive because natural parents have just a natural higher standard for you to try to take, not take their kids.
Right.
There's a presumption, basically,
Yes.
right?
Yeah, there's a presumption that they should be with them, so you have to prove them unfit.
All right, let's go back to the phones right now. We have Debbie in Myrtle Beach that's been holding on patiently. Hi, Debbie. Thanks for calling in. What's your question for the panel today?
Yes, I love your show. If you have a small trailer on a small piece of property, is it better to do a transfer on death to a friend so that you don't have to pay taxes? I'm confused about that. Why you have to pay taxes on a will and probate and all that?
Debbie, I can ballpark that a little bit. I'll tell you that trailer titles are the bane of my existence. I've done them for 30 years. I've owned about 30 trailers myself. Trailer titles are handled by the Department of Motor Vehicles, and unless your trailer has been affixed and the title retired, and there's an exact procedure in the code to do that. So you'd have to handle that by will. You can't do it like a deed, like a joint tenant with right of survivorship, where if you die, title automatically vests in the remaining joint tenant. The underlying land can be that way, but the trailer title, you have to do a will, and they're going to have to apply for the trailer title, pursuant to that.
So if somebody dies without a will and the trailer's sitting on the land, what?
I don't know if you remember that show about the trailer park that we had for a while. And
Yeah.
did you ever wonder why that fella had so many trailers? It's because, one, sometimes people abandon them. Two, they're very expensive to move. And three, the government don't want you to move them after a certain point. So he gets the title by abandonment.
So really the answer is put it in the will.
Put it in the will.
Thanks, Randy.
Now, there is a new transfer on death that is coming sometime to the DMV in South Carolina. Do you know have you heard about that?
We talked about that in the House of Delegates, and the DMV's been resistant to that.
But would that apply to trailers as well if it's a vehicle?
If it ever gets passed and gets past the DMV resistance. DMV changes very slowly, and they don't like change at all.
All right, Debbie, hopefully that helps you out a little bit. If not, find a lawyer and you can give them a call and they'll be able to help you out. Or you can email us and we'll give you an answer back after the show is over. legalaccess@WMBFnews.com. Let's go back to the phones now in Myrtle Beach. Lauren has been holding on patiently as well. Hi, Lauren. Thanks a lot. What's your question for us?
Why do judges always appoint mediators and guardians for children? Why do you have to do that? Why is it so expensive?
Well, I'm a mediator and a guardian, and it is expensive. But consider this, Deborah. The cases that
Lauren.
we used to
I
have.
think it's Lauren. Right?
Lauren.
It's Lauren.
Excuse me, Lauren. Sorry, I usually write that down. But years ago, we didn't have mediation, and you would go through the whole process and be sitting in the courtroom trying to negotiate the day of your trial. Well, the court has said, we're not going to do that. We need to know that you've done 3 hours of mediation minimum before you get a trial date. That way, you don't have a judge, a bailiff, a deputy sheriff, and everyone sitting there while you're trying to negotiate the case. That doesn't mean it won't settle on the day of court, but that means you've at least tried to settle it before the day of court.
And how about with the guardian, with minors? I think she was asking.
Oh, yes.
Guardian ad litem, I think, is probably.
Yes, Lauren, sorry, I forgot that. And I'm trying to recruit Stephanie here to the guardian list, but she's been resistant. The guardian is appointed by the court to report and observe and report to the court as what's in the child's best interest. The guardian in South Carolina cannot make a recommendation on custody. That has to be for the judge to decide based upon the guardian's report. All this is code, and you can find it if you Google it, but guardians have to be paid. They didn't volunteer, they were drafted. And the courts are going to make sure the guardians get paid. And it's very expensive to have a custody battle. We try to get those, I know Stephanie does. I mediated one for her the other day.
Yes, very good mediator.
We try to get those in mediation early before you incur a lot of fees.
And I can tell you why a guardian has to be appointed in cases is where the parents do not agree on what is in the best interest of the child. And you've got one parent telling the judge all this stuff about the other one, and the other one's talking just about as much stuff about the other one, and the court doesn't know who to believe, what to believe, so they have a guardian who can investigate these allegations and report back to them. If both parents agree on what's in the best interest of the child and can come up with an agreement for custody, you do not have to have a guardian.
And going back to Lauren's initial question about, complaining about the cost of mediation, correct me if I'm wrong, but if somebody would be able to settle their divorce in mediation, isn't that going to save them money rather than going to court?
That will save you a tremendous amount of money. And the reason judges do it, Lauren, is quite simple. They are required to appoint a guardian, and they are required now to send you to mediation. Sometimes the lawyers will pick the mediator in advance, or we have retired family court judges that are mediators, and they're good mediators. So it is a requirement. The court has no choice.
Tell you what, we're going to run to a break here real quick. When we get back, we'll have just a little under 10 minutes. So if you have any questions about family law, divorce, custody, separation, or adoption, give us a call. We'll answer them for you before the show's over at the top of the hour. So anyway, phone number's on your screen. Call us now. We'll get you on the air right here at Legal Access, brought to you by the McGuire Law Firm. We're back. It's Legal Access, brought to you by the McGuire Law Firm, talking about family law today. Again, divorce, custody, separation, adoption. Any questions on that? We got a few minutes left to get you on, but don't wait till the very, very last minute. Phone number's on your screen. Give us a call and we'll answer your question live on the air. Along the panel to do that for you today, Stephanie Vaught-Little, also Ian McGuire from the McGuire Law Firm, and Randy Mullins as well. So call us today. We'll get you on the air. Going back to Lauren's question a minute ago about guardian ad litems, we always see the movies and the TV show where they put the kid up on the stand. Hey, well, where do you want to go? Who do you want to live with? That doesn't happen in real life, does it?
Not in South Carolina. Stephanie, have you ever had a case that the child actually testified?
No, but I have been in the courtroom where the judge had ordered a sheriff to go pick the child up from school and talk to her in her chambers because of some allegations.
And usually a judge, if they need to talk to a child, will talk to the child in chambers. The judge isn't going to let lawyers cross-examine children. That's traumatic to the child, and you don't want to do that. The job of the guardian is to observe and report. And one of the things of the statutory things that we have to say is, what is the child's preference?
Right.
If they're old enough to have a preference.
Yeah, and that's weighted. Is just because a child tells the guardian that they want to live with mom, the guardian's going to try to determine why. Is it because mom said, I'm going to buy you a brand new car if you come live with me, or we don't have curfews here, or things like that. So it's not the end all. I think there's a big misconception that when a child turns a certain age, like 13 is what I've heard a lot, that they can decide, but it's not the end all.
Not in this state.
No.
We've, when I went to school in Ohio and did clinic work for free, and up there at 12, the child could file a preference. At 14, they could file an election.
Right.
But South Carolina hasn't. I've tried to get that started, but South Carolina has not bid on that by any stretch of the imagination.
Now, years ago, if you heard the word prenup, you figured it was like some rich family in Hollywood or New York or something like that. Are prenups becoming a little bit more common in places like South Carolina?
Yes, they are, especially with blended families. When you have, I see a lot with second marriages where you've got assets that you might want to go to your children, because the prenups don't only address what happens in a divorce, it also has some rights. Like Randy was talking about the elective share for a spouse, you can waive that in a prenup and stuff like that.
I'm sorry, go ahead, Randy.
We see a lot more of those in second and third marriages with older people who truly are marrying for companionship, and they want to make sure their assets go to the children. Usually there's children on both sides.
Now, we've done this show for a while, and whenever we've done family law in the past, we've had some interesting questions. We've had some people say, my husband walked out 25 years ago and I haven't seen him in 25 years. I have no idea where he is. How can I get divorced? How does that work?
Well, you can petition the court to have him served by publication. If you can't find him, you still have to do a due diligence search to try to find him. You're going to have to spend money maybe hiring a PI or somebody to investigate where his last known address was. And if all those fail, then the court most likely will allow you to publish the summons in the newspaper, and you get a divorce like that.
That's what the Ori Independent is for. Those little bitty columns in that paper, nobody reads those but lawyers. When people come in and tell me I don't know where he's at, my first remark is always, well, that's unfortunate because that's expensive. If we know where it's at, sheriff is serving for $15. If we don't know where he's at, then you're going to have to pay for the Ori Independent to publish it.
We got time to fit in at least one more phone call here. Let's go to Conway. Marie is on with us. Hi, Marie. Thanks for calling in. What's your question today?
Yes, my son had gone through the courts and got custody of his daughter, but his last name is not her last name, and we wanted to see, do we have to go through court again to have the name changed or name added?
That's correct. You do have to go through court. Stephanie, they're going to have to appoint a guardian for that, aren't they?
Yes, you have to have a guardian appointed in a name change for a minor, but it can be done.
All right, well, Marie, thanks for calling in. We appreciate that. If anybody has any further questions, we might not be able to fit you in here, but you can go ahead and email us if you'd like to, legalaccess@wmbfnews.com, and we'll answer the questions for you off the air. Now, real quick, in the minute and a half we have left, if somebody needs to change or wants to change the custody agreement that they have because of somebody moving out of town or whatever the case may be, and both sides agree to it, what's the process of being able to do something like that?
I hate relocation cases. They are the toughest cases there are. And they are case specific. Stephanie, you just had a reload case, didn't you, that you had to handle?
Yes, I did. But if all parties are in agreement, usually your custody agreement will say you can change it in writing, and issues with the child is always changeable with the court upon a substantial change in circumstances. But if both parties agree, you'll just write a new agreement or an addendum to the old one, and then you have to go to the court to have it approved so you have an order.
How about changing alimony? I mean, somebody says, I just got fired and I can't afford what I was paying my wife before, or child support.
It's the same standard on change of custody. There has to be a material and substantial change in circumstances. Permanent alimony can always be revisited by the court, but non-modifiable alimony cannot.
Yep, so you have to read that agreement that you're signing. Is your alimony going to be modifiable in the future or not?
All right, well, thanks for the call, Marie. Hopefully that helps you out. And tell you what, we're going to have to run right now because the show is over. But next week when we get back together, we'll be talking about personal injury. If you want any advanced questions to ask, you can. Legal access at WMBFnews.com, or if we didn't answer your question here today, you can email the same place. For Stephanie Vaught Little, Ian McGuire, Randy Mullins, I'm Dave Priest. We'll see you again next Thursday. Personal injury, that's our topic next week, right here on Legal Access.
You may wish to consult a lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are currently represented by an attorney, you should direct all legal questions to your attorney. The nature of any legal issue may depend on a multitude of factors. Therefore, the information provided in this program is purposefully broad and does not constitute legal advice. Please contact and retain an attorney in order to obtain case-specific legal